After the custody flip, we see judges appointing minors counsel, custody evaluators, and each one of these people can mean tens of thousands of dollars, more legal costs than you would ever spend in your lifetime, simply because you're in a custody or a divorce case. And so that was what was happening to Michael. He was fighting for his kids in another state where he didn't live. So then he had to get attorneys from California. So I'm going to tell you another little secret that the attorneys don't want you to know. And that is that the attorneys, even though the law says, and when you're in court representing yourself, you'll hear the attorneys say this over and over again. Well, you have the responsibility to act as your own lawyer and know the law, just as if you were a lawyer, to defend yourself if they don't appoint a lawyer or give you attorney's fees. Well, the law says that we have to be treated equally with lawyers when we're in court. But what the judges do is they naturally favor the lawyers, and the clients really are kind of noise. They just want to make sure that somebody's paying these attorneys. And the attorneys who are going against a self-represented party don't win because they know the law or because they have extra legal expertise. They usually win because they've been buying free lunches for the judges. They've been grooming the judges to rule in their favor. They've been sending business to judges for, thank you, Mr. Douglas. I really, really appreciate that. That helps us with gas and all of our other costs that we have in doing these videos. So I much appreciate that. So attorneys are in these local bar associations. They have the clubs and the meetings and the free lunches, like we saw last week when they called the San Jose police on me for recording that. Bill Dresser was in that video. He's one of the attorneys that is pretty notorious around here. And so that's what we see are these patterns of certain attorneys getting favorable wins from the judges. And it's not based on law or what public policy is, because public policy is that family courts are supposed to just divide people and get them on their way. It shouldn't take more than a year, but we're seeing these cases drag out 10 years because the attorneys have figured out they can make a bunch of money from it, and the judges are helping. So we're going to talk about specifically Seeley Hendrickson in Michael Sternberg's case, because, and Father in Exile, remind me, did I do a media request and that was denied by Seeley Hendrickson in that case? I can't remember what happened with that, but let me know if that was what happened, because I recall watching that case, and I don't know if it was that I read transcripts after the fact, or I saw it, or I made a media request. But what was the most outrageous about Michael Sternberg's case is that when he was representing himself, he asked for electronic access to his file. Now, let me explain what that means. The attorneys are called in this courthouse justice partners. That's just a term they made up, like they want to make it themselves out to be superheroes or something. So the attorneys make up this term justice partners, and the judges treat them differently. And the ways that we see them treat them differently is, I'll see if the sign is here. I think it is. But one of the ways that we see them treat them differently is when they enter a crowded courthouse, usually attorneys get a special line. They get a special line in the clerk's office, so they don't have to wait in line, as their time is valued, but everybody else's is not. So if you're a doctor or a contractor or a journalist or whatever you're doing in your life, you have to take time off, come down to the courthouse and wait in line, whereas the attorneys get to get accelerated so they can keep going on and making more money. But what's really insidious is that the clerk's office here closes at noon on Fridays, so you can't even go in and get court papers. They also do not allow self-represented parties access, remote access. The sheriffs are waving to us. They're showing us their new transparent through the glass. We've been through this before. So if you're a pro-per self-represented party or a member of the public or a journalist and you want to get court files, you have to physically come down here. You have to pay 50 cents a page. You have to be here when the court clerk's office is open, which is, see, the hours used to be 9 to 5, but the clerk's office now is closing and they don't even put the hours because they change it so often and it's always reduced. And so the public, journalists, litigants who are representing themselves have no ability to go in and get their papers when the clerk's office is closed. But lawyers are given electronic access to get into these court files, and they can access them 24 hours a day from the comfort of their office or their home. They can go in, they can look at their cases, they can look at other cases, they can get all of that access, and they can download files and they don't pay for it. So I want you to think about that. These attorneys who are making $500 an hour in family court and benefiting tremendously from judges continuing hearings and dragging cases out, they get to access the public court files electronically, remotely, and do not have to pay per page for every document they download. They can get into anybody's files. They can look at other cases, how judges are ruling. They can do research. And we, as journalists, can't do that same research. I have spent thousands of dollars paying for that 50 cents a page charge. In my own case, I'm on a fee waiver, so I don't have to pay, but I have to come during the clerk's hours, and they'll often tell me it can take 3 months to get your records. So Michael Sternberg is suing in federal court for a couple of issues, and if you watch his channel, he'll go over what those issues are, but that is one of them, is the lack of access. It's not equitable. It's not equitable to the public, to self-represented litigants. So while we're told we have to be fair and treat everybody the same, the reality is, as applied, these judges are giving these attorneys special favors just because they have a bar card and pay an $800 annual fee. So it's beyond the buddy system. It is the courts profiting from the public, the poor, self-represented litigants who can't afford an attorney, and the attorneys are just increasing their profits, and the judges are really kind of helping them. So let's not forget, judges are attorneys who get elevated to the bench. So Seeley Hendrickson is the judge in Michael's case. And what she did that was the most outrageous was she, first of all, would not give him access to his file. He kept emailing and saying, can someone please give me access to my file? I'm in Nevada. And she actually declared him to be a vexatious litigant for emailing the court. Father in exile, if you can post that in your community posts and show people what that order looks like, because I didn't believe that until I saw that with my own eyes. So let me tell you what declaring someone to be a vexatious litigant means. In family court, when you represent yourself, if you ask the court something that you've already asked for, they'll say that was res judicata. You shouldn't have asked. It's a final decision. You can't ask again. And they can say that if you do it too often, that they can restrict your ability to A, file lawsuits, and B, file motions in family law cases. So that law was originally intended for people that were doing kind of crazy, vexatious lawsuits. They were going after, if you remember, there were people years ago that were going after those ADA accommodations on restaurants. And I think there was somebody who was doing that. He was a disabled person, and he was going around filing ADA lawsuits on all these businesses and really financially decimating the businesses. And there is something to somebody who is litigious and filing lawsuits all the time. You know, maybe something needs to be done. But in family court, the judges allow and declare people to be declared to be a vexatious litigant after they have not made sure that there was fairness in the legal fees, meaning they didn't award attorney's fees when the law said they should have, because the law says that people should have equal access to legal representation in a family law case. And then they restrict that person. It's almost like punishing them for being poor and unable to hire an attorney. And once you're declared to be a vexatious litigant, you have to ask for permission to file any motion. So if you want to see your kids, you have an emergency, you want to move away, you need an increase in support, you can't afford the support that you were ordered to pay because you lost your job, then you have to ask the court, pretty please, can I file a lawsuit? Can I file a motion? And the presiding judge, who is Judge Emity at the time, and you might recall Judge Emity from my last live stream when she was at the Trial Lawyers Association, Judge Emity is the one that decides whether or not you can file a motion. And people who have to represent themselves don't write and speak the way attorneys do, and that really annoys me. So Seeley Hendrickson declared Michael Sternberg to be a vexatious litigant because he was emailing her department too much, and because he was asking for access to his court file. Now, on the other side of that, in that courthouse over there, which is the civil courthouse, where Judge Pennypacker is currently presiding over my civil harassment lawsuit involving Casey Halcone and Nicole Ford, the attorneys for the county council, both Hannah Godby and Sterling Leonard, email the judge all the time about things they want. And they just did that this week, and I'm going to post that in my community posts when I get back. But they just emailed the judge and asked her to use a restraining order to prevent me from saying certain defamatory statements. And that is, I'm reporting on Casey Halcone right now related to the Celeste Watt case. And so any judge that puts a prior restraint on speech, even in a civil harassment order, no judge can put a prior restraint saying, you can't say this in the future. You can't report on the future. And if Judge Pennypacker does comply with the wishes of county council, then we're going to have words about that. So, okay, Mark's going to tell us how it was.
So this is why a good process server doesn't take no for an answer and wears nice jewelry every once in a while. I went up to the courtroom. It was closed at the end of the day.